committee, so yeah, we can do that. Any questions? Oh, I'm sorry, Chairman Franklin. You're recognized. We have a motion that we give Senate Bill 136 a do pass recommendation. Is there discussion on the motion? Is there discussion? Representative Setzler.
Are we passing out the committee substitute we got here?
No.
I'm going to go.
We're passing out or proposing to pass out LC 282174.
Okay.
The bill in its original form.
Okay.
That help? Okay. Any further discussion? Hearing none, the chair calls the question. All in favor of giving Senate Bill 136 a do pass recommendation, please indicate by raising your right hand. All opposed. Thank you, Chairman Smith. It's been a pleasure. Look forward to seeing you soon. Commissioner Murray, thank you very much. Always good to see you. Tell your chief of staff I sent my regards, and I missed him today. Is Senator Hammer going to be here? You doubt it?
I don't think he showed up for any.
Josh, we have a senator here, and I'm going to take his bill up next, but would you mind calling Senator Hamrick's office and asking him if he has made arrangements on Senate Bill 57 and Senate Resolution 700? Senator Carter, come around and join us, please.
Thank you, Mr. Chairman. Appreciate the opportunity to be back
We're on
before your
Senate
committee.
Bill 196.
That's correct.
Wait just a moment till the door closes, and we can have a little quiet. Go ahead, Senator Carter.
Thank you, Mr. Chairman. Thank you again for the opportunity to bring this bill before you. We had this bill before your committee last year. Very briefly, what this legislation attempts to address is a situation where at 5:45 or 6 o'clock in the morning, a bus driver fires up the engine of his bus and at the same time fires up a Marlboro and smokes in the confines of that vehicle until the time he picks up the first child, and then in the afternoon repeats that activity. This problem was first brought to my attention a couple of years ago when I served on my local Board of Education, and a situation arose with an asthmatic child, and we discovered that the driver of the vehicle where this child, the bus this child rode each day, was a heavy smoker and would do just that, the activity that I've described. So in talking with the Department of Education a year ago about this issue, they surprisingly said that they saw this as a very important issue, and in fact had a number of calls from school systems, from parents, about this type of activity. Now, the bill does not attempt to address, and I don't pretend that bus drivers are smoking while children are on the bus. That is not the situation, and I don't think that activity is tolerated by any local school system. But there'd been a reluctance of local school systems to address the use of smoking tobacco on buses and in these vehicles at a time when children were not present. And that's what led to Senate Bill 196. We brought this bill before your committee last year, Mr. Chairman, and I appreciate the revisions to the bill. In fact, we added the last sentence, the committee added the last sentence to Section A that made it clear that this code section shall not apply to personal vehicles of volunteers, coaches, teachers, or staff of a public or private school or early care and education program. Certainly, we do not want to reach into those situations, and want this bill simply to apply to situations involving vehicles which are recognized to be used to transport children for educational purposes.
Thank you, Senator Carter. Questions from members of the committee. The committee may remember this bill was before us last year and didn't make it all the way through the process and was recommitted. Any questions? Chairman Bordeaux, and then Chairman.
Thank you, Mr. Chairman. Let me ask the Senator this, please. Wouldn't, if a school board is really against this, couldn't it simply say as part of the employment of those school bus drivers, you shall not smoke within these premises. They could say you can't smoke at all.
Absolutely, and I think many school boards have taken that action. The truth of the matter is that while school boards may have put that policy in place, and in talking with many boards of education, they have put that policy in place, there's a reluctance to enforce the policy. And the reluctance is simply because, according to them, bus drivers are hard to find. So I think by passing the bill, what we're doing is bringing this to the attention of parents. I mean, I think it makes it a little more public situation in terms of the fact that this is a violation of the law and not just a policy with no teeth.
Well, forgive me, but I mean, my concern is this. I cannot imagine that with as much as our district attorney has on his plate with violent crime, that he's going to have time to prosecute a school bus driver for smoking on a bus. So, number one, in terms of real teeth, I don't see that it would actually get enforced in terms of prosecuting anybody. And I would think the much toothier, whatever it is, way of handling it would be to say, we're going to fire you, or we're going to dock your pay if you smoke on this bus.
And I wish that were the case. I mean, I wish school boards across the state would do that. And that's why we initially engaged the Department of Education to see if this was a real problem statewide, or if this was an isolated incident that I had become aware of. According to DOE, it is a problem statewide, and they've had a lot of reports. I don't disagree with anything you're saying. And don't pretend that we're going to go out and hunt down school bus drivers to prosecute them because they've smoked on the school bus. We had even discussed at one time maybe approaching this more from an administrative fine type situation. Mm-hmm. I think the intent and the 10,000-foot level approach of the bill is to make sure that not only school systems know that this is a serious situation and you must deal with it, but also to bring it to the attention of the general public that this is a violation of the law. There have been, since I worked on the bill, of course, I've paid attention to this issue, and have frankly seen on many occasions where the bus driver pulls up to the red light and flicks the cigarette out the window with no children on the bus. And that causes me concern that systems across the state are not taking it seriously and are not dealing with it. But I don't disagree with anything that you just stated.
Thank you.
I wish I wasn't sitting here talking to you about this issue.
Okay, Representative Byrd waved off. Chairman Knox.
I don't mean this to be flippant, facetious, either one, but I understand this bill came as a result of because a child had a reaction to the smoke that was the residual smoke that was in the bus or something?
That's the way that the issue was first brought to my attention. That's correct.
Okay, and that's the objection that we're trying to solve, is that if it's causes children to have some reaction to the tobacco, that's the reason for the bill, or is it just because tobacco is unhealthy, or what? I'm not sure I'm understanding that.
No, and let me make a connection. There was as you all recall, last year we debated smoking in this legislature. That's not the intent of this bill. In fact, we looked at maybe not even bring this bill back before the committee, but in looking at the language of the legislation that was passed, it still does not address this situation. This goes to address very clearly the instance of the residuals of the smoking tobacco staying on that vehicle when children then later find themselves on that same vehicle.
What about if it's in the person's clothes? Because people that smoke, you can smell it in their clothes for about a day and a half after they smoked a cigarette, and even if they smoke it outside, it's going to get in their hair. Women particularly that smoke, you can smell it in their hair, you can smell it in their clothes, and men, you can smell it in their clothes. And generally they don't have as much hair as women do, but some less than others. But I'm just wondering, there'll be some residual on a person that smokes, period. Do we just need to say school bus drivers don't need to be smoking?
No, no, and I'm not here to reach into the private lives of school bus drivers or debate the evils of smoking. I mean, that's not the intent of the legislation at all. It's to simply say this type of activity certainly does not need to take place on the bus. And that's simply all this legislation.
But the only objection we have to it is the fact that if they smoke on the bus, there'll be residual smoke on the bus.
That's correct.
but there'll be residual smoke on the bus as a result of having smoked it if they smoke it in the restroom and then walk out and get on the bus too. That's my point.
Yeah, sure, and I think you're right. My argument would be certainly far less residual if that activity is conducted somewhere else and then they later drive the bus than there would be if the smoking activity takes place in the vehicle. But I don't deny that there would be some residual that may be found on their clothing. Sure.
Representative Tim Bearden.
Senator, I don't know what district you're from, but in my area, a lot of these buses are at people's houses.
Sure.
How's this going to be enforced? I mean, someone does get on the... Sorry. How will this be enforced if someone's at their house and they do this? I mean, how are we going to enforce this?
Well, and I'll go back to my previous statement that I don't pretend that we're going to be out looking for school bus drivers smoking on the bus. I think probably a similar fashion as the fact that we have a seatbelt law in Georgia is enforced. Many times it arguably is not enforced, but I think what that law does is bring to the public's attention the need to use seatbelts, the fact that maybe seatbelts are wearing seatbelts is a safe practice. And I think that's what this legislation attempts to do. Will there be many times when this activity occurs that the law is not enforced? Sure.
If a child has that's the unfortunate circumstance you're talking about, an asthma attack because of smoke, and unfortunately right now we do have a lot of kids that do smoke. If that child was sitting by one or close to one that's been smoking, it's in a closed, causes this attack, could you have a bus driver that's charged with a misdemeanor that really shouldn't be because maybe he wasn't smoking but a child that came in?
No, and I think what you've got to be able to do is show that the driver conducted that activity on the bus. Okay. So no, I don't see that's an issue. I appreciate your question.
I appreciate it, Senator.
Questions? Chairman Franklin.
We mentioned not wearing a seatbelt. Is not wearing a seatbelt in your moving automobile, is that a misdemeanor, or is that just you just get a citation and it's a civil offense?
I frankly am not sure what the penalty is for not wearing a seatbelt.
Would you know, Mr. Chairman, whether not wearing a seatbelt in a car is a misdemeanor subject to up to $1,000?
It is not a misdemeanor. There is a specific maximum fine. Is it 25?
But it is probable cause to stop the vehicle.
Yeah.
Mm-hmm. Even if you're wrong about it, you just think the person's not wearing a seatbelt.
Do you think that if it's not enforcing the school system's rules and regs of not smoking in the bus, not enforcing it, is because bus drivers are hard to find? Do you think they would be harder to find if they're spending up to a year in jail for smoking on the bus?
Arguably, if they're in jail, they can't drive a school bus.
That's right. So would it? You would think it would be harder to replace them if instead of just fining them or suspending them for a while. If they're spending up to a year in jail for violating this, I think it'd be harder to find a bus driver.
Well, yeah, I mean, sure. I agree with what you're saying. The fact that they would be guilty of a misdemeanor certainly raises the question, would they receive the $1,000 fine? Would they be subject to a year in jail? I can't imagine that would be the case, but certainly that's within the prerogative of the judge if they're guilty of a misdemeanor. I agree with that. As I've said, we talked about making this simply a fine situation, not classifying it as a misdemeanor. The intent of the legislation, and I'm certainly open to suggestions from the committee, Mr. Chairman, but the intent of the legislation is to raise the issue, bring it to the public's attention, to drive the message home that you can't conduct this type of activity in these vehicles. It's not necessarily to make criminals out of these bus drivers.
Further questions, Representative Jacobs.
Thank you, Mr. Chairman. I just wanted to say, to get to the heart of the matter, that there has been a lot of discussion about enforcement, but I don't think the issue here is so much with enforcement. I mean, frankly, would the solicitor in DeKalb County, prosecute one of these cases or not? I'm not sure. But the fact of the matter is, we have a lot of laws like these on the books. that are there primarily for their deterrent effect. I mean, I do think that it would have a profound impact on this activity, which I don't think is which I don't think is a good activity from a public health perspective for our children. If school systems were able to, as part of their training of school bus drivers, point this out to the school bus drivers. Frankly, if some of the school systems posted something in the school buses, that probably also would be a very healthy thing. So I think from a deterrence perspective, this is a very good piece of legislation. I'd hate to throw the baby out with the bathwater simply because some of these cases may not be prosecuted. I don't think we'd be putting this on the books for actual prosecution so much as to have a deterrent effect on this activity.
Thank you, Representative Benfield.
Responded to this, but how do you respond to the assertion that this is just more busybody government? I mean, you're over-regulating.
Well, my response to that would be that I wish I didn't have to do it. And initially when I made my presentation, what we spoke of was a very specific situation that brought this to light, and then inquiring of the Department of Education as to whether or not they had information as was this a real problem across the state. Their response was yes, and that although school systems many have adopted policies on this issue to say bus drivers cannot smoke in these vehicles, there was a reluctance to enforce the policies, and in fact this activity continued to go on, and they had been contacted by not only members of school systems but also by parents. So, I think it is incumbent upon the legislature to lead and to point people in the right direction. I think that's what this bill does. As I've stated earlier, it's not the intent of the bill to go out and seek to prosecute every bus driver in the state. It is the intent of the bill to raise this issue, to bring it to the forefront, and to make it clear that you can't conduct this type of activity in these vehicles.
Representative Byrd.
Senator, I'm sure that everyone, including yourself, knows that I went to the well last year and spoke against the smoking ban. And now, I think it's way too much government. Should we then start considering banning peanuts and peanut butter because children have allergic reactions to those types of things as well?
No. Thank you.
Further questions from the committee? Further questions from members of the committee? What's the pleasure of the committee? Representative Jacobs.
I move to pass by committee substitute.
We now have a motion that we give Senate Bill 196 a due pass recommendation by committee sub, and that's LC 291871S. Is there discussion on the motion? Is there discussion? Hearing none, the chair calls the question. All in favor of giving Senate Bill 196 a due pass recommendation, please indicate by raising your right hand. Any opposition? The motion fails.
Thank you, Mr. Chairman.
Thank you.
Look forward to my next visit.
Well, I think you'll be back in subcommittee tomorrow. I got a few of those stripes Monday night, so it happens to the best.
Thank you.
And even me. Okay, Senator Hamrick is in another meeting. If you'll come around and at least get us started. Let's take up Senate Resolution 700 first, if we could.
Thank you, Mr. Chairman. I appreciate the chairman and the members considering two bills that I have on your agenda today. And I apologize, I chair the Appropriations Subcommittee of Criminal Justice, and I'm going over my recommendations with our
You
leadership.
got the Department of Driver Services?
Yeah, I'm about to explain why we need to keep that money for the Blue Ridge expansion. And I need to get back
Anybody want to
over
talk
there.
about his bills? Or
I have a motion to pass. Second.
And I will advocate heavily when I get back over there for that great project
You're
in
a
your
great
district, Mr. Chairman. Senate Resolution 700 is the extension of the Juvenile Law Commission that we established last year. We intended it to be 2 years, and it came to the House, and I think the House decided not to do any 2-year studies, and so we're just asking you to renew that with Senate Resolution 700. We put a great group of folks together, had 5 meetings across the state. They did a lot of hard work for us, and we just want to, because the original plan was to make it a 2-year study and try to look at every angle of juvenile justice reform, including research from other states. We want to keep doing that, and we just ask you to help us reestablish that with this resolution.
Let me ask a question very quickly. There was a bill introduced in the House. Actually, there were several, but one this year that would have Georgia adopt the Uniform Juvenile Justice Compact. Am I saying the right thing, Amy? Interstate Compact. Would that be an appropriate subject for discussion by this commission, do you think?
I would think so.
Okay. And there is also another couple of bills out there, one that would open the juvenile courts to the public. Is that the sort of topic you think would be more appropriately discussed by this commission before we moved on legislation?
I hate to, I don't know
Not asking you
who's
to take a
pushing
position.
those, but I would
Yeah.
just say that anything, especially something as significant as that, would be something that we will consider, and that subject has come up several times, the subject of opening the courts, and we've
And
actually,
electing judges, juvenile judges?
that's also something that we would consider.
And I'm not advocating those issues one way or the other, but it just seemed to me that it would be more appropriate to address those through a group like this as opposed to
I would agree.
plunging head on in the middle of a session.
I'd agree, Mr. Chairman.
Questions from members of the committee? Representative Bearden?
Mr. Chairman, I'd just like to say I got the chance to sit in on this committee meeting during the summer. They did a lot of great work, and at the appropriate time, I'd like to make a motion.
You'll be recognized. Chairman Knox?
Are y'all looking at anything regarding the Department of Family and Children's Services in connection with this? Because I see they look at the child welfare system. Some might argue whether or not DPACS actually is involved in child welfare, but I wonder
Because we're looking at the entire juvenile code, it includes the abuse and neglect portions, and that's where we've dealt with child welfare issues. But we haven't expanded beyond what's in Title 15 in terms of how the juvenile court deals with cases of not delinquent children but abused or neglected children. So that's what we would be dealing with.
Further questions? Representative Benfield?
Thank you, Mr. Chairman. This is just a concern I have. A lot of the study committee or study commission resolutions. It's page 4, lines 18 to 20. It says in the event the commission makes a report, and I just think if we're spending taxpayer dollars on having this commission meet and have all these experts convene, that there should be a report instead of in the event they make a report. Was there a report last time?
Well, there was legislation that was drafted. And we're holding off on it because we wanted it to be a 2-year study, and because we planned for it to be a 2-year study, we did not do a report. We've got several drafts in the process, so our goal is to have a report, and we're actually working towards that goal. But we're not through. That's why we want to re-up it.
I'd just like to see a report, something in writing.
And as I recall, that determination that this commission needed to be a 2-year commission was made fairly early in your process, wasn't it?
Yeah, we introduced the bill in the Senate as a 2-year study, and the House changed it, and it was late in the process, and we didn't have a chance to work it out. So I just agreed to the House version with the understanding that we would establish it again, and it would be a 2-year study, and that's what we're trying to do.
Mr. Chairman.
Representative Setzer.
What would the effect be if as Representative Benefield suggested, this were changed to say the Commission shall make a report, but if the Commission failed to do that, what would the consequence be? And what's at stake? I like, frankly, them having a little
misdemeanor.
Yeah. I like them having. I mean, certainly it's their intent to get the report out. I just like giving them some wiggle room. I throw that out for discussion. I'm not sure what we'd really be accomplishing by.
Whatever the committee's will is on that, it's not something I want to get hung up on.
Jill, I don't mean to get you involved in this, but I mean, in the past, it's been fairly typical, hasn't it, that we put in there the committee shall make a report on or before?
Actually, this is standard language.
Oh, it is.
But every study committee that I've been involved with has done a report that's met. And I know when I worked with this particular committee, there was a ton of legislation that was produced, but the idea is almost a rewrite of Chapter 11 of Title 15, and although it was done in several pieces, it wasn't final. Usually the research wing of either the Senate or the House is the one that produces the report, and the members.
So what you're saying is that in the legislation creating study committees or joint committees or commissions, that this is typical language what we have before us. Okay.
And we'll finalize the report we've got, which just says that we studied it. We meant for it to be a 2-year study, and we're reestablishing it. That's the report that's written that we can finalize and file.
Okay. Vice Chairman Mumford.
The language that this resolution contains has already passed the Senate, right?
Yes.
So if we changed even a word, we'd have to go back and redo something, right? So we probably don't need to split hairs and just go ahead and pass this out just like it is.
Well, if the concern is whether we're going to do a report, we're going to do a report. So, I don't know that the language change is necessary.
Any further discussion? Questions by the committee? Recognize Vice Chairman Mumford for a motion. I'm sorry, Representative Bearden, I think it has to be. I'll recognize him for a second. Okay. We have a motion that Senate Resolution 700 be given a due pass recommendation. Is there any discussion on the motion? Hearing none, all in favor of the motion, please indicate by raising your right hands. Any opposed?
Thank you, Mr. Chairman.
Okay,
members?
I know I really wanted you to get back to your work, but would you introduce us at least to Senate Bill 57, and then you may want to defer to, I know there are others here.
Yes, Senate Bill 57 is something I've been working on for a while with my district attorney in Douglas County, David McDade, who can tell you exactly what it does in a very efficient manner and answer any questions. So if it would please the chairman, I would like to ask him to come up and explain it to you.
Mr. McDade.
May I be excused while he does that?
Absolutely.
Thank you. Thank you, members.
Do good for people of Georgia.
Mr. Chairman.
You'll be okay.
District Attorney Tommy Floyd is also here on this bill.
Yeah, he had signed up to speak. Mr. Floyd, if you want to join in the discussion. Let me ask you before we begin, Mr. McDade, are we working from the version as it was passed by the Senate last year, or as the committee sub from this committee?
LC 28 2012 is what I have that we're working off of.
All right, so we're not, what you are asking us to adopt is not what this committee did. Is that accurate?
Correct.
I think the only difference is Section 2, and that was House Bill 57, and that bill has already passed and hopefully is going to be taken up in committee in the Senate shortly. So we will be working from LC 282012, the as-passed Senate version.
Mr. Chairman, thank you. I just heard a question about a fire. I didn't want to interrupt the question about the fire.
The temperature control guy adjusted.
Okay. I smelled it too, and I was going to get out of your way if you're going to start running. Mr. Chairman, what Senate Bill 57 does is it addresses and closes a loophole in the law as it regards recidivist punishment. Under current laws that currently exist, any person that commits 3 felony offenses and then thereafter commits a 4th felony offense shall be sentenced to the maximum sentence. He shall serve the maximum sentence imposed by the court. It's recidivist treatment for anybody that commits a felony, a 4th felony. In the laws exist, the only crime that is left out of that list is the crime of murder, the most serious crime that you commit. Just through the process over the years, murder was exempted, and the history behind that was, at one time, there was a belief in the Attorney General's office that possibly that may have an impact on death penalty litigation, and they have been satisfied, and they've satisfied us that that's not an issue. So this bill simply makes a person who commits murder subject to the same recidivist punishment that everybody else in Georgia is subject to if they commit 3 prior felonies.
Okay. Chairman Knox.
I'm not an expert on recidivism, but I understand there's phenomena, according to the Department of Corrections, I think, where they track these things, that there's an aging out process in offenders where, at some point, I don't know whether it's age 40 or something like that, where the number of crimes committed by individuals starts falling off precipitously, and that most violent crime is by males between 18 and 30 or something like that.
It's the younger age population that's more violent, I think, statistically.
That being the case, and that most of the homicides that we have are not stranger on stranger. They're usually somebody, it's buddies that get drunk and start getting their guns and knives out, or domestic situations where you're not having repeat offenders in homicides very much, unless it's a serial killer, are you?
We don't generally see a lot of repeat murderers.
Right.
Murderers committing a murder, serving a life sentence, whatever that is now, and then getting out and committing a second murder, although I have prosecuted several of those, but statistically they're a minority.
Pretty small percentage. Okay, here's my question then. That being the case, and since we're struggling with this whole issue of confinements, and we're struggling with the whole issue of, because of the prison population that we have, I think we're right up there by maybe #1 in the country based on number of people that are in prison per capita basis. Am I right about that? Either one of you know? That's my understanding.
I don't know where Georgia ranks.
Okay, well, it seems to me we're like maybe #1 or 2 or something like that in the country, based on per capita. And some of that has to do, I think, with the fact that we have a lot of minimum mandatory sentencing going on. And I believe that's what you have here, is a minimum mandatory sentence for someone who commits the offense of homicide. And if you commit a homicide first, you wouldn't be sentenced to this offense. You could come out and be sentenced on a recidivism charge if you committed a homicide. See, I'm not liking this. What was that?
It was either gas or...
Well, in either case, we probably ought to clear out of here, but... that being the case, what problem is this solving then? In other words, if I commit homicide and I come out and I break into a car and that kind of stuff, snatch a purse or whatever, those could be felonies. So, but I won't get sentenced to life imprisonment for my homicide in that case. Would I just get whatever the recidivism punishment would be for having committed a 3rd felony?
What this bill says is if you are on your 4th felony and that fourth felony is a murder, if you've committed 3 prior felonies, and your fourth one is a murder, that based upon that record, you've earned the right to be sentenced to a sentence that is life that you shall then serve, as opposed to being released again and come back to reoffend.
But here's my question. Just from a recidivism standpoint, if that's the issue here, does it really make a difference whether it's a murder or it's some other felony or not? We have a recidivism statute. So my point is, if you commit a murder, the second felony instead of the fourth felony, you get better treatment, don't you? And why would that be?
The legislation that's in place today does not hold you to the severest sanction if you commit your murder as your second crime. This bill says you will now be held to the highest sanction if it's your fourth felony.
Okay, but that's my point exactly, is that why would you want to impose this sentence simply because of the order in which this event occurs? If it's if it's an issue about whether you've committed a felony, committed a murder and some other felony, then it doesn't make any difference. It shouldn't make any difference whether it's the first or the third or the fourth or whatever it is. It should be whenever you commit it, that's it. You don't even have to have any felonies. Why would you have to have 2 felonies and then commit a murder, and the murder triggers it? I don't get the connection is what I'm getting at. Do you understand my question?
I don't know.
Okay, I'm not.
If you ask me, do I think a person convicted of murder shouldn't have to wait until he's committed his fourth crime to have to serve a sentence? I agree with you. Right now, murderers are considered for release after 14 years. As a policy statement, do I believe a murderer should be released after 14 years? Heavens no. This bill moves in the direction of making a murderer ultimately serve his sentence of life. I agree with the premise of your question. If the premise is, why do you have to wait until you've committed other felonies to get the maximum treatment? I don't think you should have to.
All right. So I think what I hear you saying then is what you're really wanting to get at here is giving people life without parole for committing a murder, even without having to ask for the death penalty. So that relieves the prosecutor of making the choice, because it's not the people that are going to be up in this situation are going to be folks that probably have another offense of some kind. Isn't that what we're really doing here? We're trying to avoid the situation where you have to make an election to try somebody, and you don't want to ask for the death penalty because it's harder to get a conviction when you ask for the death penalty.
My brother here wants to speak, so
I'm not sure if I understand your question or not, but this may help. We're talking about murders that don't necessarily qualify for the death penalty. There aren't any aggravating circumstances. Another purpose of this legislation is to bring murder in line with other serious felonies where life in prison is a possibility, such as rape, kidnapping, and some others. Where now, if they are the fourth felony, the judge gives them life. It's life without parole under the recidivist statute. Currently, if they commit a murder as opposed to a rape, someone dies as opposed to a rape, then they cannot get life without parole, even if it's their fourth, fifth, sixth, seventh. If the murder is their fourth, fifth, sixth, or seventh felony. We're trying to make it consistent. It's inconsistent now.
All right. I think I'm here. I'm starting to understand what you're saying, but I thought I heard you say that your experience is that a person who commits murder is least likely to commit another murder than someone who commits some other felony is likely to commit another felony. Is that fair?
This only applies if someone has committed 3 felonies, start with that proposition, and then commits a murder. And we do the prerequisites under the recidivist statute, such as filing notice of the prior convictions and prove them up after conviction. Then the court sentences to life in prison without parole in that limited event. That, frankly, is not a lot of cases. I don't know what the statistics are, but this is not will not apply in a great number of murder cases. But where those prior felonies have been committed, whether they be prior rapes, burglaries, whatever, and then a murder is committed, that murderer should not get less time than a person that commits a rape in the same circumstance, or kidnapping with bodily injury in the same circumstance where the victim doesn't die.
Isn't murder one of the 7 deadlies? So-called 7 deadlies? So then Why can't you just travel on the 7 deadlies and not have to worry about?
The problem is the language in the original bill that says that under 1710(7)(c) that says other than capital felonies, that the fourth felony is you serve all the time of the maximum. The courts have ruled that the only capital felony in existence in Georgia now is murder. So the other 7 deadlies might apply for life without parole, but the most horrible crime, murder, doesn't, because of some court decisions that occurred after this code section.
Why did the court set that aside? Or why did they carve out an exception for murder?
Because capital felony actually means one in which the penalty could be death, and in this state, murder is the only penalty where the penalty could be death, or only crime where the penalty could be death. That's the reason.
Right. But anytime you prosecute someone for murder, you can ask for life without parole, can't you?
No.
There is no life without parole in Georgia on a murder charge unless the state seeks the death penalty first.
All right. Is there any other offense in Georgia where you can get life without parole?
Yes.
What's that?
Rape, armed robbery, kidnapping, bodily injury.
7 deadlies. But you can't, because of the carve out for murder, you can't get the. All right. So why do you have to wait till the 4th? I'm still trying to figure out why do you have to wait till the 4th felony? Why does this have to be the 4th felony?
Because that's what the law says. That's what the recidivist statute says. In this circumstance, there's several circumstances.
Okay. So y'all are trying to get to where you can get life without parole for murder, and not have to prosecute it based on the recidivist, and not have to prosecute it and not have to ask for the death penalty.
We're assuming the death penalty is not even on the table in these types of murders, because we wouldn't be having to use the recidivist statute to address it.
Because there's not aggravating circumstances.
Yes, sir.
But you can can't you ask for a death penalty even without aggravating circumstances? You have to have aggravating circumstances first? Okay.
Representative Bearden and then Representative Setzler.
I'm gonna pass and just wait to come back for a motion at the proper time.
I think we're a few minutes away from that.
I know.
Representative Setzler and then Chairman Bordeaux.
I think my question's been answered. I just want to confirm. So under existing law, if someone had been convicted of 3 felonies and the 4th offense was a rape, a prosecutor could go after life without parole under existing law.
Yes, sir.
Okay. And this is just okay. I had heard that 2 or 3 times. Want to confirm that. And all we're looking to do in this bill, with no unintended consequences, is bring murder in line with rape and those other violent crimes. Is that correct?
Chairman Bordeaux.
Thank you, Mr. Chairman. Let me get a clarification. You mentioned called this a loophole. The difference between being sentenced to life and life without parole is that a prisoner is eligible for parole if sentenced to life, and not eligible for parole if sentenced to life without parole. Either way, you're sentenced to life. The question is whether there's parole to be granted.
In practical terms, yes.
Well, in legal terms too, isn't it?
Yes.
And so what you're trying to do here is to say that the life without parole is the greater sentence than life under here. In other words, to come under the when there's a recidivist claim made for other crimes, it says the prisoner has to serve the maximum time provided in the sentence base that the prisoner would be eligible for. And you're saying the maximum time would actually be life without parole rather than life. But they're really both life. The question is, when can there be parole? Aren't you really just trying to get around the 2 strikes? Am I correct that under the 2 strikes law, that if you are convicted of any 2 of the so-called 7 deadly sins, murder, rape, whatever else it is, armed robbery, aggravated sodomy, etc., any of those 2 serious violent felonies, that those convicted of those 2 serious violent felonies are sentenced to life without parole?
Yes.
You're trying to change it so that if I'm convicted of 3 counts of bribery and murder, I go to prison for life without parole.
If you commit 3 prior felonies, whatever they are, and your 4th felony is murder, the bill would make you subject to the recidivist punishment, which would be life without parole.
Could those felonies include hindering a firefighter, transmitting a false public alarm, bail jumping, barratry, eavesdropping, furnishing a pistol to a minor, injuring a police dog? If I injure 3 police dogs and convicted of 3 felonies, and then later in my life I'm convicted of murder, I could go to prison for life without parole under this.
Under the current Georgia law, if they all meet the definition of felony, yes. And that would apply to any crime you committed that was a felony, whether it be murder or any other felony you committed. If it was your 4th felony, you'd be subject to rescission.
In other words, they don't have to be serious felonies. They don't have to be violent felonies. I could be convicted of a second offense of carrying a concealed weapon as a felony.
Correct.
Carrying weapons within a school safety zone is a felony. Carrying a pistol without a license on the second offense is a felony. Bouncing a check for more than $500 is a felony. Forgery in the first degree is a felony. Forgery in the second degree is a felony. Is it your intention that if I'm convicted of bouncing a check for more than $500, carrying a concealed weapon for the second time, and let's say 2 counts of forgery in the second degree, 1 count of forgery in the second degree, and later commit murder, that moves me from being somebody who should be eligible for parole after 14 years to someone who must be kept in prison until I die at age 90?
The short answer is yes.
Is there any cost to the state of this?
I'm certain there's a cost to keeping an inmate in prison longer than he would normally stay.
You're a DA, and you've been a DA for a long time, and prosecuted a whole lot of very, very bad guys, I know, and put them in prison for a long time, I hope. Have you noticed whether, once they get to be at about 80, 85, how dangerous they are in prison?
I hope they're not.
But when they're sentenced to life without parole, the state still has to keep them in prison, keep up their medical care, treat them as any other prisoner, at least in the sense of not allowing them to go free in any sense of the word, and pay for them.
Whatever rules and regulations apply to anybody else that's sentenced to life without parole under any other provision would apply to the person convicted under the statute, whatever those provisions are.
Had you considered, and this will be my last question, I think, Mr. Chairman, and thank you for your indulgence, had you thought of limiting these other felonies to violent felonies or something where there's harm to an individual?
The legislation that is currently in place, passed by this body, defined what those prior felonies need to be in the statute that's already current law. We're not changing the definition. The definition that applies to a 4th armed robber, to a 4th burglar, to a 4th any other felony is that which is already in the statute. No, frankly, we didn't consider having a separate definition of prior felony just for murder, which is the most serious crime. If all the other defendants charged with crimes have the same definition, we did not believe it would be appropriate to have a different definition just for murder.
Thank
you. Representative Bearden, and then Chairman Knox.
I'm sorry to have to ask questions there to my district attorney, but I feel like I have to. If someone commits a murder at age 40 and they got 45 years in jail, at age 85, they still took an innocent life, did they not?
Absolutely.
And also, it doesn't matter if you carry a gun in a school zone 3 times and get charged with felony, then you commit armed robbery. You're probably going to spend 20 years without any parole, but you have to do the same thing and go out and commit a murder. You could be out in 14 years because of the way the current statute is written, correct?
Absolutely. The current statute, and I don't want to sound trite, but gives you a benefit if your 4th felony is a murder. It exempts you from the treatment that's applied to everyone else.
And this can bring fairness to the victims of our state, could it not?
Absolutely.
Thank you, Mr. McDuff.
Chairman Knox.
There's no relationship between the felonies that have been committed before this and the murder, as the chairman was pointing out. And I think it's a point well taken. I guess it was kind of getting back to what I was trying to get at.
Not in the section we're trying to change. There is in the section before that deals with the two strikes.
Okay, but I want to just deal with this section because this is where the court has carved out an exemption. The court in Georgia
Not exactly carved out an exemption.
Well, the case law apparently has done enough in the decisions that it's causing a problem or raised some sort of a problem that makes y'all come here with this request.
There are cases where we have attempted to seek recidivist punishment for a murder on his fourth conviction the same way we have for everybody else, and the court has said no. The legislature exempted murder from that recidivist punishment, and it's got to be changed in the legislature before it's applicable. And there are cases that say that, yes.
All right, but my point is this: there's two things that we've said is that this murderer is not likely to offend again. That's one, and two, that there are two classes of murders actually. One is one that doesn't fit the category that would allow you to ask for the death penalty, and that's because there's lacks violence, that sort of thing. And apparently there's some rationale for that in that, if it's a crime of passion and so on, that the court and the legislature both looked on this as offenses of a different character, and that's why the different treatment with respect to punishment. Is that fair to say?
I wouldn't say so. Life without parole, as it relates to the death penalty, is an alternative to the death penalty. That is what it is meant to be, and that is what it is. That's why it's not available for murder, unless you commit a serious violent felony under the recidivist statute under two strikes. And the legislature, I think unwittingly, has exempted murder when there are 4 prior felonies of any kind. And then you have a murder. And I'll say again, if you have a kidnapping with bodily injury, where a person was kidnapped and received a bruise or a scratch or a bloody nose, and that's their 4th violent felony, the victim's still alive, they get life without parole. But if that person in the same facts is killed during the kidnapping, then they cannot get life without parole unless the death penalty is sought. So it's an inconsistency in our eyes, anyway.
Well, it's an inconsistency, but I don't think it's undesignedly so. I think it's because the court and the legislature both want to recognize that there are crimes that, even though they have the same title, they're crimes of a different quality. We know that based on empirical evidence that these folks don't do this again. Folks who do violent crimes in process, you ask for the death penalty. We're talking about a crime of a different character. Murder is an awful thing, but oftentimes it's a situation where it rises spontaneously, a crime of passion, as we've referred to it sometimes, and the court hasn't seen fit to allow us to impose that ultimate penalty, and that's one of the reasons why it's more difficult to get the situation that y'all are looking for in this.
If that's a question, I'll try to answer, but I don't hear a question. I wasn't.
Isn't that the case?
Not in my opinion.
Is there being thought given to whether there will be, and if so, how much of a fiscal impact this bill would have?
At one time, I believe I saw a fiscal impact report that had been generated.
A fiscal note?
Yes, sir.
Okay. And we should have asked that question of Senator Hamrick. Frankly, I forgot. Irene, are you aware of whether there is a fiscal note?
There was a fiscal note, I think 3 years ago. And I don't know if it's still current. So.
Probably not. Further questions from the committee? Representative Everson.
Mr. Chairman, I'm just throwing this out. I don't know if anyone could answer this, but you asked a question about the fiscal impact that this is going to have on the state. what is the physical impact that this has on the victim family? Thank you.
You want to comment?
I think if a murder victim's family is confronted with the real life consequence of the murderer being paroled after 14 years, you can't put a price tag on what that is. With all due respect to legislative counsel, to every entity that can calculate what it costs, you can't put a price tag on the suffering of that victim's family.
Representative Setzler.
This is a simple clarifying question. I don't know that it deals with this bill per se, but it does. It's just a question I need clarified on the overall recidivist issue in Georgia. If I were charged, or if someone were charged in a single court proceeding with 3 counts of forgery or 3 counts of bribery or 3 counts of bad check writing, I wrote 4 bad checks, that's still just one conviction, is that not true?
Charging document is one document, it's one conviction.
So,
how many counts?
So you wouldn't exhaust 3 of those in one?
No, sir.
Further questions from members of the committee? Representative Benfield.
This is a drafting question.
But on line 15, why didn't you just strike other than a capital felony? Why is there a whole new section created?
There was some concern by the Attorney General's office that would then create an impact on death penalty. And they wanted to make certain by stating clearly that this does not speak to cases in which the death penalty is involved. If you look at line 21, lines 20 and 21, it says who is not sentenced to death, that they felt it important enough to do it affirmatively as opposed to by redacting language.
Representative Mangan.
Is it possible to have a felony for shoplifting?
Yes.
So if you have 3 felonies for shoplifting, you'll go to jail forever?
No.
Is that correct?
No.
Okay. Well, under what circumstances would you go to jail forever?
For shoplifting?
If you had 3 felonies for shoplifting, and then you had, under your bill, would the three shoplifting charges qualify to
They could.
make you be in jail forever?
If your 4th conviction was murder, yes. Same as if your crime was any other crime that carried a life sentence. If you committed 3 felony shopliftings, the law currently is for any other felony that you commit. If you have 3 prior felonies, no matter what they are, you're subject to the maximum sentence.
Further questions to the committee? Chairman Franklin. Let me find out. I want the committee to have an ample opportunity. I think we're getting close to that point for questions. Any further questions from members of the committee? Hearing none, I recognize you for a motion. Representative Bearden had that motion earlier. I recognize you for the second if you desire. Recognize Representative Bearden.
Mr. Chairman, I would ask that Senate Bill 57 do pass.
Second.
We have a motion that Senate Bill 57 be given a due pass recommendation. Is there discussion on the motion? Chairman Bordeaux.
Chairman, it's a long time since I've had the privilege of considering this from a chairman's standpoint, but several years back I've had the privilege of serving on the Governor's Commission on, I think it was called Truth in Sentencing or Sentencing, and it showed one of the things that the experts, if you will, impressed upon us was the projected future cost to the state of Georgia of the prison system. And if you think Medicaid is out of control, you ought to see the figures on what the state is. And I recognize the representative's comment about the cost to the victim. It's a tremendous cost to the victim, obviously. But at some point, I believe the state should have the option of releasing someone from prison who truly no longer presents any type of danger to himself or specifically other people, and it just isn't cost efficient, if nothing else, to imprison him. It is, in a matter of 20 years, it is going to be a tremendous percentage of the state budget to house prisoners, and in 30 years it's going to be a tremendous percentage to house, imprison these 90-year-old prisoners. It doesn't make sense economically. I think there's a significant impact financially on the state. I would ask the chairman to ask for a physical note on this.
And I intend to, and I want to address that here momentarily.
Thank you.
Any further discussion, Representative Beard?
Mr. Chairman, committee members, I would ask that the committee, I understand the fiscal note, but there are victims in play here where murder is taking place, and we do not know what the fiscal note is to that family after losing a loved one, especially if it's a provider. We have a duty to make sure that these folks stay in jail that commit murder. And to Representative Mangrum, if you got 3 felony shopliftings committed armed robbery, you spend 20 years without parole. If you have them 3 shopliftings now and commit a murder, you can be out in 14 years. There is not fairness in that system whatsoever. This is bringing fairness to the system. And I believe that's what we're here about, to bring fairness. And I would ask that this bill pass. Thank you, Mr. Chairman.
Well, let me say here is what I intend to do on that. And I understand that there is a policy call and a judgment that every member needs to make, and I'm interpreting the motion to give this a do pass recommendation as an indication that at least there are some members of the committee who feel that it's more important to look at the non-fiscal issues involved. But I do think we have an obligation to at least consider the cost. And so what I would ask you to do, Mr. McDade and Mr. Floyd, is I'm anticipating this bill wouldn't be eligible for rules until at least Monday. Is that accurate? I want a message to Senator Hamrick that for those who do have an interest in the fiscal impact, that we be given an updated fiscal note by the time it gets to rules. Any further discussion? Chairman Bordeaux?
Chair, whether once we get the, I guess once we get the fiscal note, we'll have to come back into meeting and vote on it. We'll vote on that.
We have a motion now to give it a do pass recommendation, and my sense is that motion indicates that there are those, the move-ants, as it were, believe that whatever that might show, and I don't pretend to speak for them, that whatever that might show, that the other considerations outweigh it.
Yes, sir, I understand.
That's my read on that motion, and so.
Well, may I, excuse me for interrupting,
sure.
Sir. May I make one more very brief point then to Mr. Beard and some other members of the committee? I understand and I agree that for an offense as violent, as horrible, as tragic as murder, someone should go to prison for the rest of their life with no possibility of parole. And the cost to the victim and the victim's family and society of killing a person is tremendous and perhaps beyond compare. But remember what this bill is saying. This bill isn't saying that for murder you go to prison for the rest of your life with no chance of parole. This bill is saying for murder you go to prison for the rest of your life without parole if you bounce 3 checks. that's the part that truly doesn't make sense to me. If we're going to say that for murder you should go to prison for life without any chance of parole, then let it be for the murder, not because perhaps 20 years earlier you improperly influenced legislative action. That's a felony in Georgia. That would qualify under this for your recidivist count. Early in this session, I approached the District Attorney's and Prosecuting Attorney's Council about a bill. I found I don't do any real criminal work, and I found out that in order to seek life without parole, the prosecutor has to first ask for the death penalty. That's nonsense to me. That's absolutely nonsense, because they may not feel death is proper in that case. The death penalty is proper in that case, and they may think, gee, this guy should be he should be off the street forever. But yet they've got to seek the death penalty first to get life without parole. And I approached the Prosecuting Attorney's Council about a bill that would say just that. You can seek life without parole without having to first seek the death penalty. And they said no, they didn't want that. They didn't want to mess with that. And I understand the reasons. The reason was that they were concerned that it would mess with the death penalty statute. They're so afraid of messing with that that it might, that they were content to first require seeking the death penalty before you seek life without parole. But to me, that's the way to address this, is let the jury sentence the person where there's aggravating circumstances, where the jury desires to life without parole. Not make it because you committed 3 other credit card forgeries, in my opinion. Thank you.
Thank you. Any further discussion? Any further discussion? So, Representative Mangan.
There's no time. There is no timetable involved in this either, is there? For example, if you can get a felony for any of number of things, and what if a person is led an exemplary life 20, 30, 40 years when they did something, they did have a bad teenager years, early 20 years, and they were great, but in the heat of passion they committed this murder thing. Not saying, and it's a battered husband. He's been battered his whole marriage. And he just couldn't take it any longer. And he didn't really, there's a basis. There are facts that I think and I know there's a policy decision also, my colleague, why you would, and if there are some inequities, let's look at them, but this is one of those where you're going to hamstring something. Just go ahead and sentence the person, because it just seems unfair also, likewise, that when I was a teenager, I really didn't have any guidance and I was just a delinquent and I did bad things.
Chairman Knox.
Mr. Chairman, I'd like to propose a motion that we postpone consideration of this matter until we have a fiscal.
Is there a second?
Second.
All right, now we have a substitute motion that Senate Bill 57 be postponed until we obtain a fiscal note, and it would be my intention to expect to receive that by Monday, and then we'll look at putting it back down if the motion is adopted. Is there discussion on that motion? Representative Beard? Excuse me?
We're going to go through the whole debate again, or we're going to be prepared to vote?
No, we're going to vote. The way the chair sees it right now is that we have a motion that would simply postpone further consideration till we have the fiscal note, and then we would consider it further with that fiscal note. If that motion is passed, then we're through for today, and if it fails, then we're back to your motion. Is there further discussion? Hearing none, we will call the question on the substitute motion, which would simply be to postpone further consideration of Senate Bill 57 until such time as we have a fiscal note. All in favor, please indicate by raising your right hands. All opposed? Okay. Did you record? Did you vote? Okay. Just making sure. Okay. All right. We will look to have a further discussion on that. We stand adjourned, subject to scheduling of the subcommittee meetings. Thank all of you for being here.